Well, maybe I will go ahead and get started. Thank you all for joining today's Bench2Market talk. Today's topic is intellectual property strategy. I think it'll be a great event, but right before we begin, I just wanted to give a few updates and a few deadlines that might be of interest. So my name is Courtney Law. I am the Managing Director for Biolocity. We are an early stage funder here at Emory and Georgia Tech. And we actually currently have a funding cycle open. So if you are a member of one of those communities and have a technology that you're interested in looking for funding, please feel free to reach out to us. I'll give some information of how to connect with us soon. But the Bench2Market Talk series is co-sponsored not only by us, but with the Georgia CTSA and the Pettit Institute for Bioengineering and Bioscience. So this talk series goes throughout the school year. So again, we have today's talk, but our upcoming talk will be on FDA regulatory strategy. If you want to see this full series schedule, please feel free to go to our website at biolocity.Georgia Tech, and you can register for any subsequent talks there. As I mentioned, our next talk is around FDA regulatory strategy. It should be a great talk about discussing the differing regulatory pathways, and will be hosted, or the discussion will be led by a regulatory consultant, Grace Powers. An upcoming deadline that you all probably know about is the biomedical engineering department has a capstone design project. And they are currently accepting applications for spring 2022. And the deadline is actually December 10th, so this Friday. If you have any additional questions or want to know how to apply, please feel free to contact Kyle Caldrick. His email is listed on this slide. As a part of Biolocity's offerings, we offer commercialization resources, including legal office hours. If you're interested in speaking with one of our, or a professor at the Emory School of Law, please feel free to reach out to us. Again, just visit the Biolocity website and we will help get you connected. Another thing that we offer at Biolocity is a connection through the BARDA Drive network. BARDA is, sorry, I'm not sure why my slides just keep advancing, so my apologies. BARDA has several areas of interest that are currently open for funding and partnership. They offer grants up to $750,000, and these are the current areas of interest that are open. If you're interested and you feel like your technologies or research fall into any of these categories, again, please reach out to the Biolocity team, and we can talk through not only the application process, but make connections directly to their program office. And so without further ado, I do want to introduce our great speakers for today. So we have Christopher Close and Sarah Wilkening, both from Troutman Pepper. They both have had extensive experience with working with not only IP strategy, but working with the universities as well. And so I think that they'll be able to provide a lot of great information to each of you around IP strategy and how it could be useful at your stage of technology. Following their presentation, we'll have Q&A moderated by Biolocity's Associate Director, Dr. John Nikosha, who also has experience with working in the technology transfers here at office here at Emory. And so I think it'll be a great discussion. If you have any questions during the talk, please feel free to leave it in the chat or in the Q&A section, and we'll make sure that those questions are answered. And so with that, I will stop sharing my screen and turn it over to the team.
Awesome. Thanks, Courtney. Let me get my screen shared. And there. Can we see the slides?
Yep,
we can hear me? I'm not on mute. Okay. Well, thank you guys for coming to joining this event, and thanks, John, for inviting us to come speak to this audience. I think this talk will be really helpful for those budding entrepreneurs, inventors, university researchers, and maybe just those that are interested in how you can protect your inventions. But this talk, since we don't have that much time, Rusty and I wanted to kind of take it from a more practical standpoint of asking the question of, is a patent right for me or my invention? So speaking with me today is my colleague, Rusty Close. He is a partner at the Atlanta office, and I am a patent agent at that office. And yeah, so we're just gonna take it from here. Here's our typical disclaimer that we have to provide. Essentially, although we work for Troutman Pepper, that is not the opinion. These slides aren't the opinion of the firm. These are mine and Rusty's opinions. And this does not create an attorney-client relationship. So it's just typical disclaimer, but moving on. So who cares about IP and patents anyway? Well, hopefully at least all of you guys here. So that's great, because Rusty and I also care about IP. But IP and patents in particular can be really thought about as ways to protect your invention by using law. And this can be it can be both offensive and defensive. It can be offensive in the sense that it can help ensure a startup company can secure investments. It can also try to stop competitors from entering into the market where your invention is trying to take place. And even if you aren't trying to commercialize your product, it can add commercial dimension to your research and also have a broader impact. So it could be beneficial even just from that standpoint. Defensively, it can also help establish a record of prior art and also prevent others from stealing your invention. So Rusty, what rights do you get with a patent?
Yeah, so that's always a good question. I think it's
okay, sorry, there we are.
I think it's something that people typically misunderstand. You know, they think, okay, I've got a patent now. That means I can do the thing that I want to do. And it's important to keep in mind that it's actually the inverse of that. It's an exclusionary right. And so, you know, when you get a patent, what you're actually getting is the right to keep others from doing the thing that you have invented, right? So it's not a matter of, well, now that I've got my patent, I can go out and I can make or do or sell or license the thing that I've invented. I can keep others from doing those things. And if we have some time at the end, we'll go into a little bit of an example of, you know, the nuance there, because it really is a little bit tough to square away in your mind. And I think it'll be helpful. But, you know, what we want to talk about here is, okay, well, I've got an invention, and should I think about getting a patent? Would a patent make sense for me and what I'm doing? So we're going to kind of walk through an example where Sarah has invented something, and I'm going to use that term loosely, as you'll see on the next page. And let's just talk through what that discussion should be, either, you know, sort of your internal dialogue, or you're talking with your team, or, you know, if you're at a university and you're talking with your licensing agents, and you want to think through why it might make sense to pursue a patent on this idea you've got. So you want to unveil your invention to them?
I do. So here I am. I come into your office, you know, when it's safe to, or I wear a mask, and I want to know if I should get a patent for my pet displaying bag. This is my great invention. I believe it's new, and I haven't seen anyone else having this. What should I do?
So I think the initial thing is when I stop laughing, I'm probably going to just ask you to leave, or how you got in the building to begin with. But let's just say we're you know, suspending disbelief, and we're going to talk about, you know, this invention here. And so, you know, the things, when people come and they've got this idea, right, and they're really hot to trot on it, the first thing I always hear from them is, well, other than we got to file this everywhere, right? They want to get worldwide rights on this thing. The other thing is that we got to do some searching, you know, and I always have to stop and say, okay, well, what do you mean when you say searching? So people want to do diligence before they file a patent application. They want some certainty that if they file, at the end of the day, they're going to be able to get this patent. So what we call that is a patentability search. And what we're going to do with a patentability search, if we end up doing a patentability search, is we're going to search high and low, right? We don't have to just look at patents. We have to look at, you know, PetSmart catalogs, and we have to look at Etsy, and we have to look at all of these places to try to find what the patent office calls prior art. Because when you get a patent or when you pursue a patent, the patent examiner is going to look and try to find anything else that's out there so that he or she can tell you, well, you didn't invent this. This already exists in the world. And so when we're talking about patentability, that's what we're looking for. And that prior art, it really can be anything. They can find anything as long as it came before, you file your patent application. And there's two types of, prior art. So there's what we call 102 prior art. And that's, hey, look, Sarah's invented a baby Bjorn for dogs. And we go and we find a PetSmart catalog that has the exact same thing, right? And so that's what we call the novelty standard. Is your invention novel? And if we find something that's dead on, then the answer is no. We have found 102 art in the space. The other type of thing we look for is non-obviousness, right? So your invention has to be novel. It has to be non-obvious. And so non-obvious means that the patent examiner can combine different things that he or she finds, right? So, I think I look at this and I think, well, I know a baby Bjorn exists, right? And I could go and find other, sort of carrying mechanisms for pets and say, well, it's obvious to one of skill in the art to combine these things, right? And so that's what we call 103 obviousness type prior art. And so when we're talking about patentability, and what I usually kind of caution people is, look, that's not an easy search to do because, like I said, we're searching for anything under the sun. It's easy enough for us to look for that 102 novelty art. Is there anything that's just directly on point for what you've invented? It's not easy to look for those 103 combination references because examiners have so much leeway in terms of what they can combine together to reject, your patent application. And so when we're talking about should we spend the money on a patentability search, what I often advise people is, look, as we're writing a patent application, we're gonna look for stuff to see what's out there. We're gonna try to hit the low-hanging fruit so that we can go ahead and distinguish ourselves from what we've already found. But that's just sort of a low-level initial patentability search. We're not going to do it. There's no true utility in spending $5,000 or $10,000 or $30,000 on a patentability search because you're never going to get it. You're going to get closer and closer and closer to certainty, but you're never going to get there. And when you file a patent application with the patent office, part of the fee that you pay to them is a search fee. And so I always just say, look, you're going to pay the examiner to do their job anyway. Let them do their job. And then we'll deal with the stuff that we find. We're going to already find the stuff that we think is really close, but we're not going to kill ourselves looking for, everything under the sun. So, in terms of patentability, should we do this? That's kind of the discussion that I have. Is that sort of your experience, Sarah?
Yeah, absolutely. I think one thing that we're going to kind of distinguish during this talk is a little bit just what Rusty talked about is the patentability assessment or search, but also we're going to uncover a little bit more about also freedom to operate when clients come to us asking for, what is the risk of someone trying to assert their patent rights against my product? And then we'll touch a little bit on invalidity, but we don't want to go into all of that until we kind of uncover some other components. But I think, Rusty, I think you're exactly right. First of all, I'm surprised that you know what Etsy is. So that's really great to know that. Now we can have that in our normal conversation.
I'm really into crafts.
Okay, so, well, I don't believe that baby borns are obvious to this. So I think that my invention is useful and it's novel and it's not obvious. These are the kind of points that Rusty was talking about that he would talk about with the 102 and 103 issues. But there isn't any legal requirement to do a patentability search, like Rusty suggested. maybe your dog wants to fit in my bag.
I think he might be too big.
There's no legal requirement to do this, but there are ways that you can help save money if you do decide to file a patent by doing your own searching on your own time. you may uncover some relevant art, or you may find on Etsy that this has already been done. Or if not, it can also help, if you do decide to patent it, it can help the drafter of whatever, it could be, you know, a patent attorney or agent. You can help them write better claims because they know it's already out there and they can potentially distinguish. So how do we do these searches when someone comes to us? This is something that also a lot of university licensing managers will be able to do as well, or have some feedback for you. But when we do our patentability searches, we typically start with just a typical Google search, you know, or Etsy search is probably going to be part of my list now. But Google Patents is very user-friendly. There are some other databases that once you try to get more into the nitty-gritty of what you're looking for, that could also be useful. In particular, if you're in the small molecules research area, SciFinder, if you have access to it, most universities do. You could use SciFinder to draw your structure, and then you can look at both patent literature and non-patent literature. If you do want to invest a little bit more in this search, you can hire a patent search company. There are handfuls of companies that could do that. You can also reach out to patent professionals, people in law firms. But kicking it up a notch, I actually learned a lot of this Boolean syntax methods by a librarian at Emory, came to talk several years ago. And maybe the university librarians would still be willing to do that and help you. If in your search you do uncover a patent that's similar, you can use what both US and international patents use, the CPC, the classification. That's going to be a combination of letters and numbers that kind of categorize the invention. That could be helpful along your way. But so for example, here's a search down below in the search bar that I tried to search for my pet carrier briefly. And this is more of an iterative process, right? You're not going to get it the first time you put in the search terms. And so like, for example, prior search, I uncovered over 100,000 references. But when I try to focus more by searching in the claims in particular with these exact words, I was able to narrow it down to 105 results. So that's something that could be beneficial. But again, you know, this is still at the beginning stages before you file. Rusty, what happens if I have a product and I want to come to you for freedom to operate? Can you talk about what we would expect with that?
Yeah, well, and before we move on, I want to hit two other points on the patentability search. So one thing to consider is, look, anything that you uncover that is material to your technology, right? And there's a standard that we use, but just kind of think if this is relevant to my technology, relevant to the patentability of my technology, you have a duty of disclosure to the patent office. So you have to make them aware of everything that you find as you're doing this search, everything that meets that standard. So sometimes it's not, you know, it's maybe not the best idea to just go looking and looking and looking and looking, because you're putting a little extra burden on yourself as you put this, you know, as you end up filing your patent application. The other thing is, you know, Sarah hit on this at the beginning. She mentioned Google Patents, but she also mentioned Google. You know, if you're looking for patent publications, there is those publications or those patent applications do not publish for 18 months until after, you know, they were initially filed. So there's this significant lag time. And so if you're looking for something that's sort of dead on to what your new cutting edge technology is, you know, Sarah's invention notwithstanding, and it's in a patent application, it's unlikely that you're going to find it anyway, because it's not going to have published yet. And so, you know, Google or some of the other tools that can help you look for academic articles and things of that nature are much more likely to find something that's on point to what it is you're doing. So, you know, all things to keep in mind when we're talking about a patentability search. But once we've had that discussion and we go back to my initial question, like what kind of search are you talking about? The other, you know, sort of leg there is a freedom to operate search, right? So, you know, this is more if you have a product. This is more if you know, I always think of this as you've got an actual tangible widget that you want to do something with, but it doesn't have to be that. But the idea there is, look, I've got this thing that I want to make or sell. And my question is, if I do that, am I going to step on anyone's toes? Is it safe for me to sell this thing? Am I going to get sued if I do it? And so freedom to operate is the sort of analysis or assessment that we would do to try to come to a conclusion on that question. Now, we call it a freedom to operate. That's not really the right name for it. What I usually try to characterize it as is a risk assessment. What are the risks associated with me selling this product? Similar to the patentability, we're never going to get a full-on 100% guaranteed answer. So for me to say you have freedom to operate, I'm probably going to get myself in trouble if I do that. There are legal opinions that are considered sort of more like a freedom to operate, and those are quite expensive, in the neighborhood of $100,000 or something like that, where the attorneys will go through, they will do an exhaustive and extensive search. Often it will be a situation where someone has a product and they know a competitor has a similar product and they know a competitor has a patent on it. And what we're doing is sort of certifying that your design, in our legal opinion, is not going to infringe that patent. And there can be a lot that goes into that analysis. But for a freedom to operate, or what I would call a risk assessment, I'm going to do the same things. Now, patentability, right? We said we have to look for anything under the sun. Etsy and Google and Amazon and, PetSmart catalogs. But if we're looking for freedom to operate, we're only concerned with patents that are in force, right? So we only want to look at it. It closes down the universe of things that we have to look at significantly and takes much more of a burden off, and therefore can give us a little more certainty about the answers that we're giving. We're not looking for unpublished applications that we're not aware of yet. We're only looking at patents. And so we can go through, we can do the search, we can find the specific patents that kind of cover or closely cover our technology, our baby born for pets. And then we can start to compare our technology to the claims in those patents, right? So this is probably a good, kind of lesson in patents. One, it's not an affirmative right, it's an exclusionary right. Two, what is it that you have, what that right applies to? It's the claims at the end of your patent. And so many times I'll talk to people and they'll say, well, I've got a patent for that. Now, many times they don't have a patent, they've got a pending patent application. So they don't even have any rights to begin with. Two, if they do in fact have a patent, they will confuse the idea of, well, I have a patent for that. They'll be thinking of everything they discussed in the application itself and not realizing that the protection that they have is for those claims at the end of the application that were, that we went back and forth with the examiner and we narrowed and we got real specific with the language. And that's the thing that you have a patent for, not everything that you discussed in your application. So we're looking for patents. We're going to go and we're going to look at the claims specifically in view of our baby born for pets. And we're going to try to make a determination of whether our invention meets every limitation in those claims. Because in order to infringe, we have to do exactly what's set out in those patents. And so, that's a little bit of analysis that we have to do. It's helpful if we have a product so we can kind of compare it and then touch it and feel it and make sure that it does or doesn't do those things. But if we compare to the claims and we ultimately decide, look, we found 6 patents. These were the only ones that were even reasonably close to being in the space, and you don't do those things, we think your risk is really low if you sell this product. Maybe we find a patent that has claims that are close to our technology or that we think we might infringe. Well, then there's other things we can do. Sarah, we talked about, we can do potential design arounds, and we can, let's talk about design arounds first.
Let's do it.
Invalidity is a little tougher.
Yep, exactly. I think you're right. One point to make though is that even though some patents are not issued yet, sometimes pending patents just provide uncertainty in the scope. One thing to consider also with the freedom to operate or the risk assessment is what are your competitors doing? Can we focus on what they're doing? Do they have patents that could be similar and then could be broadened in and continuation or further applications that would be filed later that then would encapsulate your product. So that's another way you could also focus your risk assessment, and also focusing on the specific countries as well. But
yeah, so
I think
let me butt in real quick, because you're early in your career and you don't know this trick yet. That's where you put caveat language in the risk assessment, right? So
yeah.
we've only evaluated patents that are in force right now. And that's exactly the right point, is we want to identify really who might your competitors be and look at their patents. And that way we can say, now look, these guys do have something pending that could eventually mature into a patent. We should continue to monitor that, all of those things. But, I think that's the way that, look, we're doing this as thoroughly as we can, and we're giving you the best risk assessment that we can. But like we said, it's not 100%.
Yes, I think that's right. So specifically looking at the claims in these freedom to operate risk assessments, in this particular case, in my baby display, or not baby, yeah, you got me all mixed up, my pet display bag, I pulled up in my search this pet display vest. And I don't know if it could be, my product would be infringing on this. And so what I would do would be specifically looking at the claims and trying to figure out if this patent here would prevent me from selling my product. And looking at the claims, I didn't copy and paste them onto the slide, but in general, this particular patent, first of all, it's expired. So no longer enforceable. That's another point. It has to be an enforceable patent. This one's expired. It can no longer be enforced against my product. But they also have specific claims that require tubes and passageway for an animal to fit completely in. So that, I think that means that mine's around that, right? Because my pet fits outside of my container. I would imagine that would be how I would get around, designed around it, essentially.
I just want to be sure. I don't know how clear this is on everyone else's screen, but as I look at this picture, this looks to be something for a hamster or a gerbil or a mouse, where they have a connected inner tubes that they can run around this person's body, which I guess is why you get that goofy look on your face if you are wearing this. But this is quite an impressive thing that someone spent money on to get a patent.
Yes, yes. But I was having trouble finding an actual product in the market for it. So that's why we stuck with the pet carrier. So now, what if this patent was enforceable though? And the claims were kind of touching on what my product is. Now this is something that, and I can't design around it. I already have a product made. I have enough to be sold. I don't want to go back into the drawing board and make a different product. Can we talk about how we could invalidate such patent on different grounds?
Yeah, I mean, so this is where things get tricky, right? You are fully committed to having this product, and maybe you were a little late in thinking about these things, and you've got a whole production run of them already built. You've spent money, it's already out there, and oh man, I should get the lawyers to look and make sure there's no patents for me to infringe. And then we come back and we find something and say, hey, look, this looks pretty close. And you say, well, I can't modify mine now because the horse is out of the barn. So one option is, okay, well, let's look at if we think that patent is potentially invalid. In other words, should this person have never gotten the patent in the first place, right? The patent office just made a mistake, which absolutely happens. And so there's a variety of ways that we can look at a patent to think about, is it potentially invalid? So one of them is, we talked about 102 and 103 art earlier. We can do our own search, or we have potentially done our own search at this point, and we say, look, there's all this prior art out there that the examiner didn't find. There is no way that this patent should have granted in view of this prior art that we found. So that's one way we can look at it. Another way we could look at it is go in and look at the claims and see if those claims are supported by the specification, right? So the idea with your claims is that you can only write claims that are backed up by the technical disclosure that you made in your application. And so a lot of times as you're prosecuting a patent application, meaning you're going back and forth with the patent office and arguing about what the claim scope should be, limitations will get written into the claims, whether it's to avoid a different prior art reference or whatever it might be, that honestly aren't as supported by the actual application as they should be. And so if we go through and we see, oh, you can tell that this got added sometime during prosecution, and there's no way that one could reasonably suggest that the inventor had possession of this part of the invention when they wrote this application. So maybe that's an avenue that we could, invalidate this patent. Another avenue is, what we talk about, patentable subject matter. And so this could be a whole other series of discussions. So I'm going to keep this really high level, but in about 10 years ago, the patent office decided that, okay, there's certain things that we're going to, really clamp down on that aren't patentable subject matter. And a big one relates to computer technology and what they call abstract ideas. Another version of that is more in the life sciences field. You can't get a patent on things that occur in nature, and you can't get a patent on, there's another one I'll let you
isolated DNA.
Right. So things of that nature. So if the patent is about those things and not about, baby Bjorns for pets, then that's an avenue of potentially, trying to challenge it. So we want to invalidate the patent. It could be for patentable subject matter. It could be because there was prior art that was already out there, or it could be because, the written description doesn't support the claims. Now, I say all of this as, look, we're doing a risk assessment and we're talking about, okay, what are the risks associated with practicing this product? Trying to invalidate a patent is going to be an expensive and time-consuming thing, right? So that's something that, okay, well, this is nice to have in our back pocket, but it's also not something where we're starting to file the paperwork and go ahead and invalidating it. Because with this patent that we found, one thing we're going to look at is, look, has this person ever asserted it against anyone else, right? Has it ever been involved in litigation? Or does this patent owner, whoever it is, assert any patents against anyone? Have they ever been involved in patent litigation? Because we might find, well, they've never, it's not something they do. So the risks of them all of a sudden, getting into patent litigation might be low. And also remember that if they think there's a problem here, they might try to, they're going to send us a letter and tell us there's a problem and to stop doing it. And that just starts another discussion with them, right? So that might be, look, we've already looked at your patent. We think it's invalid for A, B, and C reasons. Then they come back and they say, well, we disagree. So we'll license the technology. You pay us $2 for every baby Bjorn you sell. And then we think about whether that makes sense. And we think about, well, should we just buy the patent from these people? So there's all sorts of ways that this can go. And when we're doing this risk assessment, it's way more nuanced than, do you or don't you infringe a patent that's out there? And so we always try to take that kind of business-minded approach to the technology that people are bringing to the table and trying to decide, whether it makes sense to pursue the patent, do the patentability search, or sell the product, do a freedom to operate assessment, and thinking through, what is going to make sense for this person, this inventor, this company, based on their goals and their current situation. So I think, that kind of gets us through patentability assessment, freedom to operate assessment, some of the thoughts that go along with that, the type of art that can be used against us, 102, novelty, 103, non-obviousness, all of the things. It's kind of this gumbo that you're going to be making in your mind as you sort of think through, as the inventor of some sort of technology, what is it that I should do with this? But we've got some other considerations, as you're developing your technology and starting to talk about it with people. And, okay, well, I want to at least go, maybe I want to, raise funds, or I want to, bring on investors, or potentially have people work on this for me. What do they need to be thinking about in those circumstances?
Exactly. You walked right into my next slide. Thanks for that. Right. And now that we, maybe we do have something that we do want to protect, you need to be cautious. Talking to other potential investors is still a great idea, but maybe do it in such a way that you're not exactly telling them how your invention works or what exactly your technology is. But if they do push back, maybe that's time to consider a non-disclosure agreement or some sort of confidentiality terms. Just touching on a little bit of why it's a concern. There are disclosure bars in certain countries. Most countries outside of the US will not allow you to get patent protection if there's any disclosure before you file. However, the US does give you a 1-year grace period if it's you or someone through you does disclose in some way. So for example, presenting internally for your lab may not actually result in a public disclosure if it's just internally. But if you do have other people coming to those meetings, maybe that's time to consider, keeping your invention a little hush hush or having some sort of non-disclosure agreement. But I think Rusty, you've convinced me that maybe patenting my bag isn't for me. And for anybody that is concerned, this is essentially all that we've thought about talking about currently. We have more that we could talk about, but we want it to be more directed to what your questions are. So moving into questions, before anyone asks, that pet display bag is available from Walmart for $51. So I did not invent that, unfortunately. But yes,
well,
we open any questions.
We could talk about inventorship and how you have a duty to the patent office to, you have to attest that you actually did invent something, right? So people get concerned all the time. Well, if I go and I show this to somebody, they're going to take my idea and try to patent it themselves. And, one of your protections in that case is that, well, that person's going to be committing fraud on the patent office. So, we have some other avenue of recourse. I wanted to, before we get into the Q&A, because I think we got a couple more minutes, I was going to do a quick example about sort of the exclusionary right. And I think, it's an important takeaway, and I think it'll help kind of keep it straight in your mind what we mean when we say that and why, I don't even understand how this works. How would it work that way? So let's, suspend disbelief a little bit more, perhaps more than we did in the Pet Baby Bjorn example. And let's say that Sarah was the inventor of the ink pen. So, her invention more or less is an elongated tube.
I have one that looks like you a little bit.
Yeah, right. It's very nice. It has a reservoir for ink on the inside, and it has a roller ball at the end of a tip for, dispensing the ink onto a piece of paper, right? So Sarah has invented the pen with components A, B, and C. And so she can prevent anyone else from selling a pen that has A, B, and C. So I come along and I say, well, Sarah, I've noticed that your pens have a problem, and it's the ink always dries out on them and no one can use them anymore. What I have invented is an improvement to your pen. It's your components A, B, and C, your original pen, with my improvement, component D, which is a cap that goes on top, right?
Sounds pretty smart.
It's really ingenious. I go to the patent office. I now have a patent that covers the invention that is A, B, C, and D. You have a patent that covers A, B, and C. I have a patent that covers A, B, C, and D. Now, Sarah has the exclusionary right to keep anyone from selling anything that is A, B, and C. So my problem is I cannot sell my pens with caps. I have a patent for them, but I can't sell them because she can keep anyone from selling something that is A, B, and C.
That's right.
Well, we're at a bit of an impasse now. She, on the other hand, can't sell her pens with caps either. And so both of us have this patent, but it's not really allowing us to do much. It's allowing us to kind of be in a standoff. And so, again, because we're going to look at this as business people and not as academics, we can go about this a lot of different ways, right? I mean, we can enter a licensing agreement where she has a license to my patent, and now because she's already selling pens and maybe I don't have manufacturing and all of this other stuff, I say, sure, you have a license. Now you can sell pens with caps and you pay me a royalty from that. You know, so there's lots of different ways that can go, but I think it's a helpful example to kind of keep in the back of your mind in terms of why it's okay, what do you said it's an exclusionary right? What does that mean? And I think it's a simple enough example that'll kind of it will hopefully help you keep it straight in your head. So do we want to open it up to questions? Do folks have questions at this point?
Yeah, first of all, thanks so much for a great talk, Sarah and Rusty. I think that was really useful and informative. I don't currently see any questions in the Q&A box, but please feel free to submit those either there or in the chat. I have a couple questions, maybe just to get the conversation going.
Absolutely.
So you touched on this briefly when you were talking about public disclosures and wanting to be careful about this. And I think that there's kind of this natural tension for academics because there's pressure for them to publish their work and share their knowledge with the world. So do you have any advice for kind of how to navigate that tension between the need to publish your work and then wanting to be careful to not kind of create your own prior art or jeopardize a future patent application?
Yeah, I mean, that's a great question. And, we have this beautiful tool that the Patent Office provides to us called a provisional patent application. And many, many times when we work with our university friends, they will call us last minute and say, our inventors are presenting at a conference tomorrow. Here is their paper. Please file this as a cover sheet provisional. And, that provisional, what you're doing there is you are more or less just putting your stake in the ground at the patent office that says, hey, I'm going on record that I have invented this and I haven't yet disclosed it to anyone before I filed it here. And that will preserve, sort of your rights to foreign file later and file in the US. It gives you 1 year to do those things. And so there's a ton of nuance that we could go into, but the idea to keep in mind is, look, if you think you're going to be publicly disclosing your technology, and it's not just talking about it in a high level, it's sort of disclosing it in a way that someone of skill in the art could make or do the technology without undue experimentation. That's kind of the standard there. Then it might make sense to just go ahead and file a provisional either on your paper that kind of goes down into the weeds. If that doesn't exist, then write up as much about it as you can, and we can file that as a provisional. I mean, Sarah, I assume that you used that strategy plenty when you were in your previous lifetimes.
Yeah, well, I haven't lived that many lives, but yes, the one thing I would say for those researchers in university settings is that when you're submitting your peer-reviewed paper for peer review, it usually takes a couple of months to do, right? Unfortunately, it is a slow process, but you can get your tech transfer office on notice that you are submitting it. And by that time, you'll have a fully fledged draft, hopefully, and they can start thinking, well, let's actually analyze this for its commercial potential. Likewise, if you are a grad student defending, most universities allow you to embargo your dissertation. So a lot of times your public defense or your thesis defense is public, but there may be ways, and John, I don't know if you know this or not, but some universities I think may allow you to have your dissertation to be non-public, but then you can have your dissertation embargoed for I think up to 1.5 years. That gives you plenty of time to put your licensing associates and any patent professional on notice that, hey, maybe we should consider this for filing. And that way we don't have to do last minute provisional, but that is still also a really good option to do in those, emergency fire situations.
And I think, if we want to be practically speaking, right, I think people they can hear this and they can get a little concerned that, oh my God, I need to have an NDA in place anytime I'm going to talk about my technology. Practically speaking, that's probably not true. It's probably not practical. But again, that standard is, can this person you're having this conversation with, make or do your technology without, undue experimentation? And the other part of it is this is up to a patent examiner to go and find out about this discussion, which is very unlikely. That's why when we talk about a paper that's going to be published, that's something that they can find this discussion that you may or may not have had with someone, again, practically speaking, is probably not something that a patent examiner is going to become aware of. And so, there's a little bit of a balance there, just to kind of keep in mind, okay, yes, we want to be cautious, we want to be thoughtful, but let's not also, kind of be ridiculous about this.
Yeah, I think those are both fantastic points, Sarah and Rusty, especially about the NDA. I know that a lot of investors, in particular, when you're in early discussions with them, might not want to sign NDAs, especially if you're having an introductory conversation, because there are a lot of, legal obligations that go along with signing an NDA, and they don't want to have to keep track of what information is confidential. So if you can find a way to non-confidentially talk about your technology at a high level, you really lower your risk, as Rusty said. So I think that makes a lot of sense. And then one last plug for our tech transfer offices. I think, to this point, engaging with your tech transfer office early, even before you maybe have reduced your invention to practice and you've got a really solid description of it, just talk to them about what your ideas are, and they can help guide you kind of on the next steps to make sure you don't, accidentally disclose something. Okay, so we did have a couple questions come in. One of them says, going back to the FTO and risk assessment, if the investor says, I don't think you have FTO based upon prior art, what are levels we can do to satisfy them to show non-infringement and invalidity? So yeah, does that make sense?
Sure, yeah, I think so. I mean, so if the investor said, we don't think you have freedom to operate based on prior art, my first question with them to the investor would be, well, what did you find? Because we're not talking about prior art here. We're talking about patents specifically. And, and that happens all the time. People kind of get those terms mixed up in their mind, and they worry about, oh, I found this patent application. Well, I'm not worried about a patent application. I'm worried about a patent. If it does turn out that they have a patent, what we could do is, there's a lot of ways that you can kind of evidence this, right? It could be a claim chart. And so you go through, I usually do it in Excel because it's got nice, easy boxes for me to fill in. And I put, here's what the claim elements are. And I might have another column that says, and here is the support in their specifications that describes what that claim element means. And then I'll go through my product and say, here is my product and how it doesn't meet, that claim recitation. And so, I think that's an easy way to kind of walk through it. It's visual for me, which makes it a lot easier to understand. And I can kind of see, okay, well, here, I'm showing you here, and here, why we think this is a low risk situation. Now, let's say we're in, Sarah's situation where we found the dead on patent, and now we're having to talk about invalidity, potential invalidity. I think what we're going to do there is say, here are, the potential shortcomings to this patent. And it's probably going to be a written document. And again, this gets expensive because this is like opinion of counsel. And it's going to be, here's what these claim elements are. We don't think this is supported in their specification because their specification says this, or they said, we can go back in the file history and see what the people said, or, on paper to the patent office during prosecution and say, look, here, they even said this here. And so that kind of contradicts what they're trying to say if they were to assert it against our product. So again, it's all kind of written work product at this point that would be kind of explaining, hey, here's the problems with that patent and why we don't think it's as much of a risk as it could be.
Got it. Thank you. That was really helpful. Another question we got was about the infringement exception for medical procedures, which I think is an interesting topic. So this person asks, what counts as a medical procedure and who gets the exception? And how does that in turn affect claim strategy if you were going to file a patent on something like that?
Wow.
That's a fun one.
That is far outside my area of expertise. I stay away from anything that's life sciences related. Sarah, do you have some insight on that?
I do. Wow, look at that. Let's just glorify this moment. Yes, so it's physicians that are excluded from patent infringement if the claims are around the terms of a method of delivering a catheter or some sort. Typically, when we draft patent claims, we're really going to focus on the device first. And then if the device isn't available or certain aspects of the device are unavailable, we can actually focus on methods of making such device. And that actually goes towards infringement of the manufacturers. That gets around the trying to claim infringement against or assert infringement against a physician that is using that device. That's typically not going to be your best strategy to go after that physician, since the goal is to treat patients. But going after the manufacturer, or maybe even going after indirect infringement or contributory infringement, could be the way to go. So depends on how you draft your claims. You're right.
Yeah, and I think, part of the thing to keep in mind too is, like, again, this is the academic versus the practical. And okay, well, let's say someone did have that patent. It's like, okay, first of all, what are your damages because this physician did this thing? Is it, the entire industry is doing this and they're infringing your patent? And, is because if they got the product itself, they're going to have some implied license to be able to use the product. That's kind of comes along with what they purchase. So yes, I think, Sarah, you're exactly right. It's you're writing claims that are more tailored to the product itself, and not, if we can avoid it, a method for using that product.
Yeah, thanks. I think that was a really great answer. And it speaks to, I think, the spirit of that exception, which is that, we don't want to prevent doctors from doing something they have to do to save someone's life, right? But we could try to prevent a manufacturer of a device from making something that you're trying to sell to help them with that. But it is frustrating because, I remember from my days in tech transfer, we'd see some really great disclosures on, I've got this fantastic new surgical technique. No one's ever done it before, and it's going to revolutionize the way we treat some kind of disorder. And we can't patent a surgical technique, a medical procedure. But maybe there are things that
you could try to patent it. You just won't really be able to enforce it. It's not going to.
That's a better. Thank you.
That touches on our earlier discussion about the patentable subject matter. And one of the sort of excluded categories is what they call methods of organizing human behavior. And a lot of those sort of procedures and protocols and things that, hospitals and doctors spend a lot of time investing in and researching and figuring out sort of the best way, the best protocol, the best way to go about doing a certain thing to kind of minimize risk and make sure it's done right. It's not a good fit for patents. And that can be a big frustration because they'll spend all of this money putting these resources into this research, and they can't protect it at the end of the day. And it's like, they don't want to be selfish, right? They're coming up with this for the greater good, but they've also invested in it and they'd like to be able to protect it some way, somehow. And it's just not a perfect fit in our kind of IP world, the stuff that's available to them. And so, that could be another panel discussion about how do you protect something like that. But patents aren't the best way to do it.
Right. Yeah, that's really tricky. Speaking of things that patents might not be the best way to protect, I wonder if I could get your take on stuff like, artificial intelligence or machine learning algorithms. I know we've got a lot of researchers at Georgia Tech and Emory that work in this space. And from my understanding, they're pretty notoriously difficult to protect. So what are your thoughts on, the patentability of those types of technologies in general? And then if not patentability, what are some other ways that we could protect these kind of very software heavy inventions?
Yeah, it's a great question. It's a huge topic that we deal with all the time. And I would almost say, well, how much time do you have? Because we can talk about it for a long time. I tend to advise people that, if you come to me and what you're talking about is very heavily algorithmically based, let's just start from the standpoint that we're going to have trouble. We're going to have a hard time at the patent office. Now, part of the issue is you can get a patent for it, but you will have to put so much detail about your algorithm and system into your application and your claims, and specifically your claims, that your coverage is going to be very narrowly tailored to your exact implementation. And what you've done at that point is you've given all of your competitors the recipe for what you do, and you've given them the exact recipe of what they can't do. And so you've given them a huge head start because you've had to disclose all of this information. And personally, for me, I don't think you've gotten very much out of it other than, I think it's been more advantageous to your competitors than to you. And so what can we do? Well, for me, that's something that I would counsel people to look, you need to protect this as your trade secrets, right? We can implement a trade secrets policy that you use internally, and we protect it with the end user agreements that the people who are using your software are going to sign, right? So they're not going to reverse engineer. They're not going to decompile. They're not going to try to look under the hood and come up with what you've already done as they use your system. And so this really becomes more of a contractual protection than a specifically IP related protection. But anything where it's algorithmically based, or if it's something that I would kind of characterize as a decision-making tool, feed it in a lot of information, and it's going to spin out and spit out to you, here's what you should do. Based on all of these criteria that you've given me, here's what you should do. Very difficult. If you're taking in information from sensors, sort of actual physical data that's being analyzed and processed, and then the system then spits out a control that makes something occur in the real world. So it's not a decision engine, it's actually affecting a change in the world. You have a much better chance there. So if you just think about cruise control or a thermostat in your house, it's just kind of the examples. And if you kind of have those two separate in your mind, like if it's cruise control or a thermostat, I got a reasonably good shot. If it's a decision-making tool, I'm going to have problems. And just sort of start there, and then we can have the discussion in terms of like, so what should we do?
Great, thank you. Yeah, that's great advice. So I think we've got a couple minutes left. If there's any other questions, any last minute questions from our audience, please feel free to drop them in. But otherwise, I'd just like to take this opportunity to thank Sarah and Rusty again. I think this was a really great chat. So thanks for stopping by and sharing some of your wisdom with us. And I also just remind everyone, as Courtney mentioned in the beginning, Biolocity's funding cycle is now open. So if you or anyone you know or an Emory or Georgia Tech researcher looking for some early commercialization support and funding, you can find a link to request a meeting with our team right on Biolocity's website, and we'd be happy to chat with you.
And John, how many rounds of funding does Biolocity offer?
So it's one funding cycle per year, and we're kind of in one phase. Typically, our funding is from 12 to 18 months. And we look for something that's at kind of early proof of concept stage, and hopefully has, you know, at least some IP ideally around it, or at least a plan for IP. But we'd be happy to engage and address those questions in a meeting for sure.
Perfect.
All right. Well, thanks again, everyone. And please come back for next month's Bench2Market talk.